we head to Olympia, Washington for a hearing. 26-year-old Brianna Caldwell has been charged with assault. 2 months earlier, police say Caldwell was entering a casino with her husband, 30-year-old Michael Hammock, when the two got into an argument and she punched him in the face. Hammock, who suffered a facial bruise, called police and Caldwell was arrested. She was released on her own recognizance, but the judge issued a personal protection order preventing Caldwell from having any contact with her husband. And since, according to police reports, she'd been drinking the day of the incident, Caldwell was also ordered to wear a scram tether and abstain from drug and alcohol use. But after her tether indicated she'd consumed alcohol multiple times and that she'd removed the device, a warrant was issued for her arrest. Today, Caldwell appears virtually before Judge Kayla Wilcox because the alleged victim, Caldwell's husband, has asked that the PPO be removed. Also present is public defender Josh Pazderker.
So this is a request by Mr. Hammock, but Ms. Caldwell, we've issued a warrant for your arrest as you're not in compliance with the court order. Are you in a treatment facility?
Yeah, I just did a drug and alcohol assessment.
When are you starting treatment?
Monday.
Monday? And how do I know that you're starting treatment? I don't have anything in the court file and pretrial services doesn't know.
Well, I'm calling my probation officer today to check in because today I have to check in. But also,
There's nothing other than non-compliance. The bracelet was removed on the 19th of August, unauthorized. How come?
I cut it off because I was drinking.
You're out there violating the court orders.
Well, I'll go turn myself in today. I could do that. I could go put the scram device back on today. I'll go do those things. But this protection order with me and my husband, I live with him. I've been married with him for 2 years. This is...
I'm not going to change the release conditions, Ms. Caldwell. Turn yourself in. Get yourself to Thurston County Corrections Facility. Get yourself turned in.
I will. Thank you so much. You have a great
day. Do it today.
After Caldwell abruptly leaves the hearing, her husband, the alleged victim, wants to be heard.
Can I speak?
Mr. Hammock, I'm not taking up the hearing until she comes into compliance with pretrial. She's got to turn herself in. Not going to hear any more from you, Mr. Hammock. I appreciate this is difficult, but she has to comply with the court order.
It's more than difficult. This is destroying our family.
I'm not changing that order until she gets herself into compliance.
I'd be able to get her in compliance if you could take the restraining order off so I could help her. She needs my help.
No, Mr. Hammock, I've made the decision.
No job, no license,
she goes into
nothing.
Treatment, she goes into jail.
So you don't want to help her, you just want to make it worse. Okay.
We're done, Mr. Hammock. There's nothing I can do with you. So she knows what she has to do, so we're done. That's all. So you can leave the meeting.
Judge Wilcox kept the protection order in place, and since she failed to turn herself in, Caldwell's warrant remains active. She's yet to enter a plea, and her case is pending. Next, we go to a hearing in Montesano, Washington. Judge Dave Edwards presiding. 28-year-old Max Tracy's been charged with domestic violence. And since that charge was filed 6 months ago, Tracy has allegedly violated 3 no-contact orders with the victim. State Attorney Jason Walker is asking to roll the 3 violations into one case, a common request in domestic violence cases.
I'm ready to hear it. So the vast majority of the evidence in this case is all the same. The witnesses are the same, and it's the same victim. So it's strongly in the interests of judicial economy to join all these charges.
All right, thank you. Mr. Tracy, do you wish to respond to that motion?
Yes, I believe if I'm doing this right, I would object to that.
Tracy, who's being held in the county jail, has chosen to represent himself.
These are all separate circumstances, and none of them are in the same circumstances. So for them to be joined together would 100% be prejudicial against my case, and it would not allow me to have a proper, fair chance at trial.
After hearing Tracy out, the judge makes his ruling.
All right, thank you, Mr. Tracy.
Thank you, Your Honor.
The court rules are rather clear. There's no reason to have 3 trials on these 3 cases when they contain so much overlapping evidence and identical witnesses. So I'm going to grant the state's motion. All 3 of these cases will be joined for trial.
Can I say one more thing, Your Honor?
No, I've already ruled, Mr. Tracy. Mr. Walker, Mr. Tracy, you're going to be found in contempt. Knock it off.
Tracy claims, incorrectly, that he doesn't have access to a law library.
Mr. Tracy, there is a law library at the county jail. If you're having trouble accessing it, I suggest you Mr. Tracy, you are now in contempt of court. Be quiet. Listen to what I'm telling you.
By now, both the judge and the defendant appear frustrated.
It is not my job to assist you as you prepare for this trial.
How am I supposed to actually prepare myself for trial if I don't have any law material, Your Honor? This is crazy.
Mr. Tracy, you're the one that forfeited your right to counsel, not me. You've created the problem you have, not me.
I object to this whole hearing. Let's go. I'm done. You guys are scrub, man. Get it dry.
All right, Mr. Walker, please prepare another order on contempt.
In the span of 2 minutes, Tracy is held in contempt not once, but twice. He was sentenced to an additional 30 days in jail. His domestic violence case is pending.
And then we tried to have consensual sex. That didn't work over this apartment because he couldn't perform.
We're in Olympia, Washington for a hearing. 56-year-old J.D. Messner and 65-year-old Julie Davidson have applied for anti-harassment orders against each other. 2 months earlier, Messner, who manages the Whispering Woods mobile home park, got into an altercation with Davidson, who lives on the property. Messner says Davidson threw some items at him and grabbed his body camera, which he's required to wear for work. Davidson admits she knocked some stuff off of Messner's desk, but denies touching him. Today, both parties appear without attorneys before Court Commissioner Paul Wall because Messner's previous protection order issued against Davidson is about to expire.
All right, Mr. Messner, I'm going to let you go first. As the original petitioner. And then after that, Ms. Davidson, I'll hear from you. Okay, Mr. Messner.
Okay, Ms. Davidson had come into my office to talk about the inspection that I did about 2 months ago now. I had a body camera that my management company requires me to wear when I'm out on the property. I reached over and turned it on, and when I did, she snapped and went ballistic. And she made the threat. She goes, "Remember, I have a gun and I know how to use it."
Your Honor, I don't have a gun to my name. My children stole all my guns. They're gone. The only thing I have is pepper spray. I've lived at the Whispering Woods trailer park for about 15, 16 months. J.D. Messner and I became instant friends. The next thing I know, we're going out to dinner. That's how well we hit it off. And then we tried to have consensual sex. That didn't work over this apartment because, well, never mind. He couldn't perform. But I really liked him, and I want to apologize to you personally. I just want you and I to get along and work together. But your nuts are tied for management.
Now, Ms. Davidson, let's take a breath.
I'm
here.
sorry. I'm sorry.
Everybody take a breath.
I just want things to work out.
No, it sounds to me like you don't really want an order against Mr. Messner.
I don't.
Okay.
And I don't think I deserve one against me either. We have to live 50 feet across from each other.
It sounds to me like Ms. Davidson doesn't want that order she applied for, so I'll just allow her to withdraw that.
Okay, Your Honor.
Thank you.
After Davidson's order is withdrawn, the commissioner moves on to Messner's request.
You know, this comes down to whether Mr. Messner has proved to me by a preponderance of the evidence that there's been this course of conduct done by you, Ms. Davidson. I'm concerned that there's a lack of proof. The evidence is not strong enough on that. So, Ms. Davidson, what that means is I'm not going to issue an order against you as Mr. Messner requested.
Thank you.
And with that, the hearing comes to an end. Before leaving, Davidson approaches the bench to retrieve some paperwork.
Thank you, Judge.
You're welcome.
Can I have a handshake?
That's okay,
No,
ma'am.
okay.
Yeah.
Thank you.
I appreciate the sentiment, but
I
we don't
appreciate
do that.
you.
Okay.
Both petitions were dismissed, and the case is now closed. We're in Longview, Washington for an arraignment. 38-year-old Christopher Belvoir has been charged with resisting arrest and disorderly conduct. Several hours earlier, Belvoir was arrested for wandering around a YMCA at 4 o'clock in the morning. Police were called to the scene, and after the defendant failed to cooperate, he was arrested. At the time, Belvoir was free on a personal recognizance bond for assault and other charges. His bust at the Y was a violation of his bond conditions. Today, he appears remotely before Judge Edward Putka. And right off the bat, things get off to a rocky start.
There are two charges here, resisting arrest and disorderly conduct.
Hey, can I tell you something, sir?
Just a minute.
I didn't do either one of those things, sir. So
Okay.
your charges and your officers is outrageous.
Mr. Belvoir, if you keep talking like that, I'm going to send you in the back, no bail, and we're going to come back to you tomorrow.
All I was doing was trespassing at YMCA.
Mr. Belvoir, one more time, you're using obscenity in this courtroom, and I'm going to put you in the back. You're not going to get out of jail. Just listen.
I want my lawyer present right now.
Okay, just listen up.
Desmond Cloaky, I'm not going to listen to you with a bunch of fake charges.
Okay, just take it easy. Okay, calm down.
Okay, go ahead. Read out the fake charges, sir.
All right, so the charges are resisting arrest and disorderly conduct.
They're both lies.
Okay. The maximum penalty for this is 90 days in jail and fines and cost of $2,050. Do you understand what you're charged with?
Yes, sir.
The judge goes on to explain the defendant's rights before turning to defense attorney Oleg Balaban.
I find probable cause for the charges. Do you want to enter not guilty, please, on his behalf, then, Mr. Balaban?
Yes, Your Honor. I said not guilty. Plead not guilty.
Judge Putka asked the state for its bond recommendation.
The city is recommending $1,000 bail. The problem is he's got other pending cases between July and today, and he was presumably released on recognizance on those cases on condition that he stay out of trouble.
That $1,000 bail in your court, in your system, is kangaroo court. Excuse my language.
The judge remains calm as the defendant continues to argue.
Sir, look, I'd like to change judges or whatever the hell. This guy is biased against me, and if you guys keep me in jail for something I did not do, the police assaulted me after I was walking away peacefully.
You want to talk about bail? Mr. Balaban?
Yes, Your Honor. I just suggest we set for a pretrial at this point.
All right, I'm going to set the pretrial on October 6th at 10 a.m. Mr. Belvoir, your behavior convinces me that you need to stay in jail.
Sir, I would like to make you not my judge and my behavior in court. Guess what? Sir, I got my ass whooped by your little bitch ass officer.
The bail is $2,000 cash. $2,000.
No, you're not getting me any bail.
After setting the bond at $2,000, Judge Putka sets a date for a pretrial hearing.
October 6th. That's all.
Listen to me. I have the right to change my judge. You guys hold me in jail. You will be fired, make you sir. Yeah, this is the officer right here last night that hurt me. You know what? You guys are all
Belvoir failed to post bond and eventually pled guilty to all charges, including his earlier assault charge. He was sentenced to a total of 24 days in jail. Next, we head to Shelton, Washington for an arraignment. 34-year-old Richard Smith has been charged with driving with a suspended license.
Mr. Smith is charged as a misdemeanor and is punishable by 90 days in jail and $1,000 fine.
Presiding Judge George Steele then reviews the defendant's rights.
You have the right to be represented by a lawyer, and if you cannot afford a lawyer, you have the right to have one appointed for you at no expense.
A standard procedure during an arraignment. But Smith, who's appearing today without a lawyer, has got questions.
Did you have any question about those rights?
Kind of, yes. Corpus delicti in this case is kind of funky, being the state of Washington. It seems to be me to be a fictitious plaintiff. In a sense, I can't subpoena a plaintiff that doesn't exist as a person.
Okay, we're going to talk about a couple things first, because what you're saying is gibberish. You don't even know what corpus delicti is.
Corpus delicti produce the victim.
No, that's not what it means.
Definitions here.
Here's the situation. I'm gathering, it sounds to me like you might be kind of dabbling in the sovereign citizen stuff.
No.
Sure sounds like it.
The sovereign citizen stuff that Judge Steele mentioned refers to tactics employed by individuals who somehow believe the law is illegitimate and answer only to their own interpretation of it.
Here's how it works. Pay close attention. Simply because the fact there's no, quote, identifiable victim doesn't mean its behavior is not a crime.
The judge decides to schedule another hearing, since the ticketing officer did not provide enough information in his report. The defendant simply needs to sign a document agreeing to return.
Am I being penalized if I don't sign?
I'll have you thrown in jail if you don't. Does that sound like a penalty? Don't challenge the authority of the court.
Smith eventually complies, signing the release, but he adds a line about being under duress, which irritates Judge Steele.
Let me see it.
Proceeding under duress.
Reprint the order.
The judge rejects Smith's amendment to the order and has a second one printed, identical to the original.
Sign the order. Just your name, nothing else.
I can't. That's...
Just sign the order. You're ordered to do so. If you don't, it's contempt of court. You're not under duress, but you are under court order to sign the order.
Smith signs the new copy of the order, but defies the judge and once again adds his claims of duress.
Have a seat. You're in contempt of court.
Okay.
The maximum penalty for contempt of court is 30 days in jail and a $500 fine.
I'd sign it with my rights reserved then.
Signing this does not take anything away from you, sir, as far as your rights.
Why do I have to sign it then?
Because I just told you to, because it gives you notice when your next court date is.
I'm gonna sign the order, then I'm gonna...
You're gonna sign your name and nothing else. Anything else, you're going to jail.
Smith complies, and Judge Steele purges the contempt charge. Before things wrap up, the judge has a final word of advice for Smith.
My suggestion to you would be that you should probably spend some time having a brief consultation or a longer consultation with a lawyer.
That's pretty much a waste of my time.
Sit down. I purged the one contempt. I don't need any editorial comment on your part that this is a waste of your time. I don't care if you can believe it. And outside this court, you can say anything you want. You can tell everybody I'm the devil. I don't care. You have a right to speak. Don't say a word. But inside this court, you're going to show respect for the court. That means when you're directed to do something in the court, you're going to do it. You're free to leave.
Okay. Thank you, Your Honor.
Smith failed to appear at his next hearing. There is currently a warrant out for his arrest.